You are a law-abiding gun owner. You have done nothing wrong. You are not prohibited. You are not flagged. You are not on any list. You legally own a firearm, and you simply want to buy a box of bullets. Not a gun, bullets. And the state of California tells you, prove it, every single time. Not once. Not with a license. Not with the background check you passed last week. A brand new background check at the point of sale every single purchase for the rest of your life. And if a government computer glitches, if there is a typo in your name, a missing hyphen in a database you have never even seen, you are not delayed. You are denied. Your constitutional right, gone because of a data entry error in Sacramento. This is not hypothetical. This is California law, and it has been since 2019. Today, we are breaking down the case that is fighting back Rhode versus Bonta and everything that happened in that Pasadena courtroom on March 25th, 2026. Stay with me. Every source is pinned in the comments. Go verify it yourself. Let's get into it. Before we go any further, I want to say something real. This channel is called Firearms Law Advisor. We are brand new, and the support from this community has genuinely blown me away. Right now, we are sitting just 500 subscribers away from 2,000. If you have been watching and you have not subscribed yet, now is the moment. Hit that subscribe button. It takes 2 seconds. Then come down to the comments and type 3 words. Firearms Law Advisor. Just those 3 words. I read every single comment personally, not a bot. Me. I will thank you by name. You are building something real with me here. Now, let's get into the case. To understand what happened in March 2026, you need to go back to where this all started. In 2019, California rolled out one of the most restrictive ammunition purchase laws in the entire United States. Born out of Proposition 63 and reinforced by subsequent legislation, the law requires every single ammunition purchase to be accompanied by a point-of-sale background check. Not once, not annually, every time. You buy a box of ammo on Monday, you need a fresh background check on Friday. There is no carryover. There is no cumulative license. Every transaction resets the clock to 0, and it gets worse. California also made it illegal to order ammunition online and have it shipped to your home. Every single purchase must happen face-to-face with a California licensed dealer. You cannot go to a national retailer online, even a completely legal one, and have ammunition delivered to your door in California. That avenue is completely shut off. The lawsuit that rose up against this law is Rhode versus Bonta. It was filed in 2018 by Kim Rhode, a 6-time Olympic medalist in shooting sports, a woman who has competed for the United States at every Olympic Games since 1996, from Atlanta to Rio. She joined forces with ammunition retailers and the California Rifle and Pistol Association, backed by the NRA. This is not a lobbyist's fight. This is an American athlete who looked at an unconstitutional law and said no. The case landed in front of federal Judge Roger Benitez in San Diego. In April 2020, Judge Benitez ruled the law unconstitutional and wrote one of the most powerful lines in Second Amendment legal history. He wrote that the experiment had been tried, the casualties had been counted, and that California's ammunition background check law misfires. Then came Bruen in 2022, the Supreme Court's landmark ruling that reset the entire constitutional framework for evaluating gun laws. The case was sent back down. Judge Benitez ruled again in January 2024, again striking the law down. California appealed. In July 2025, a 3-judge Ninth Circuit panel affirmed Judge Benitez and entered a permanent injunction against the law. California Attorney General RhodeVBonta came back in August 2025 and petitioned for en banc review, meaning the full court. The Ninth Circuit granted it in December 2025, allowed the law to remain in effect during the appeal, and scheduled oral arguments for March 25th, 2026. Let that sink in. This law has been struck down twice by a federal district court judge and once by a 3-judge appellate panel, and the state of California has kept fighting every single time. At what point does that become government abuse of the legal system? Drop your answer in the comments. March 25th, 2026. Pasadena, California. 11 judges. Final arguments in Rhode versus Bonta. And I want to walk you through exactly what happened in that room, because the exchanges between the judges and the attorneys tell you everything about where this case is headed. First, the support for the gun owner side was extraordinary. The United States Department of Justice walked into that courtroom and argued in favor of striking down California's law. 25 states filed amicus briefs on the gun owner side. side. 25 states and the federal government stood in front of the Ninth Circuit and said, "This law violates the Second Amendment. That is not a small thing. That is a political and legal alignment you rarely see." But despite all of that, the oral arguments were tense, and I want to be honest with you, the panel was more hostile to the gun rights side than many legal observers expected. One of the most damaging exchanges of the day came when a judge pressed California's attorney on the law's failure rate. The data shows that approximately 11% of everyone who tried to buy ammunition under this law, roughly 50,000 people, were either severely delayed or denied outright. The judge asked California directly whether evidence showed that a significant number of those people, possibly a majority, still had not received ammunition 6 months after initially being rejected. California's attorney responded that 60% of that 11% were eventually able to get ammunition within 6 months, as if waiting half a year is a reasonable answer, as if telling someone they have to wait 6 months to exercise a constitutional right is anything other than an effective denial. One of the judges fired back immediately. The paraphrase was something like, "That is a little like saying that millions of people have been able to speak and we are only saying that this specific group cannot. That does not help your argument." And then there was the question of the remaining 5%, approximately 20,000 people, who never received their ammunition at all. California's attorney never gave an adequate answer. Instead, she pivoted to arguing that the law should be challenged as an as-applied challenge rather than a facial challenge. In plain English, she was saying, the law is fine in general, maybe just these specific plaintiffs have a grievance. The judges noticed that pivot. It is a legal dodge, and it was treated as one. Another brutal exchange came when a judge pointed out that California's background check is only valid for a single purchase. He asked California whether they had any data showing how often law-abiding gun owners suddenly become felons between one ammunition purchase and the next, because that is the only logical justification for resetting the entire background check process every single time. California's attorney admitted she had no such data. None. There is no data because the premise has no factual foundation. California kept trying to reframe this law as a licensing regime, similar to concealed carry permit systems that the Supreme Court has already approved. But here is the problem with that argument. There is no license. Nobody in California gets an ammunition license. What they get is a one-time use background check that expires the moment the transaction closes. Calling that a licensing regime is not a legal argument. It is a rhetorical strategy designed to obscure what the law actually does. When the attorney arguing for the gun owner's side stepped up, the dynamic in the room shifted. The interruptions became sharper. The pushback was more aggressive, but the attorney held her ground, and she made one argument that I believe cuts to the heart of this entire case. The law, as written, says that if a purchaser's information does not match a record in California's automated firearm system, the transaction shall be denied. Not may be denied, shall be denied. So if there is a typo in your name in a government database, a missing hyphen, a data entry error that has nothing to do with whether you are a prohibited person, you are denied. And the law does not require the state to cross-reference another database. It does not provide any further process. It just says denied. Try again later. One of the judges compared this directly to being told you cannot speak because of a government data error. Is that a constitutional system, or is it a system designed to fail law-abiding people by default? Tell me what you think in the comments. Here is where I have to be straight with you, because this channel does not traffic in false comfort. The Ninth Circuit en banc panel has a track record that matters here. In March 2025, just a year before these arguments, an 11-judge en banc Ninth Circuit panel reversed a ruling that had struck down California's large-capacity magazine ban in Duncan versus Bonta. That case had been won at the district court level. It had been won at the 3-judge panel level. The full court reversed it anyway. The Ninth Circuit, at the en banc stage, has not overturned a California gun law in recent history. Not once. That is the environment this case is walking into. The composition of the panel matters. These 11 judges were selected at random from the Ninth Circuit's active judges. Based on the makeup and the tone of the arguments, there is legitimate reason to be cautious about the outcome. Cautious, not hopeless. There is a difference, because here is what has changed. The Bruen framework is now binding on every federal court in the country. Under Bruen, California does not get to argue that this law is good policy or that it reduces crime. California must demonstrate that this ammunition ammunition background check has a historical analog, a comparable restriction that existed at the time of America's founding, and California has not been able to identify one, because there is not one. There is no historical tradition in this country of requiring citizens to pass a government check every single time they purchase ammunition, separate from the purchase of the firearm itself. That has simply never existed as a regulatory practice in American history. If the en banc panel upholds this law in spite of that, if they reach past the Supreme Court's own binding instructions in Bruen, they will be creating the exact kind of case the Supreme Court may feel obligated to take. There is no circuit split on this specific question right now, which makes it harder to get the court's attention. But a Ninth Circuit decision that blatantly conflicts with Bruen's own framework is a different kind of problem. That is a credibility problem for the circuit, and the Supreme Court has stepped in for less. A ruling could come anywhere from a few months to over a year from now. California's ammo law stays in effect while we wait. I want to take a moment to talk about the person whose name is actually on this case, because she is not a political symbol. She is a real person. Kim Rhode is a 6-time Olympic medalist in shooting sports. She has competed for the United States at every Olympic Games since 1996: Atlanta, Sydney, Athens, Beijing, London, and Rio. She is one of the most decorated Olympic shooters in American history, and she is a California resident who watched the state make it harder and harder to practice the sport she has dedicated her life to at the highest level of competition for 30 years. She has been fighting this case since 2018. 8 years through district court victories, through appellate wins, through en banc delays. She stood on the courthouse steps in Pasadena on March 25, 2026, after those final arguments, and said she was there to see it through to the end. That is the spirit of this case. Not a corporation, not a lobbyist, an American athlete who looked at an unconstitutional law and made a decision. I will not stop. Here is where things stand. Rhode versus Bonta has been in federal courts since 2018. Federal Judge Roger Benitez struck down California's ammunition background check law twice, in 2020 and again in 2024. A 3-judge Ninth Circuit panel affirmed the injunction in July 2025. California secured en banc review. Final arguments took place on March 25, 2026, with the U.S. Department of Justice and 25 states arguing on the gun owner's side. The arguments exposed a law that denies constitutional rights over government database errors, a law with an 11% failure rate affecting tens of thousands of law-abiding people, a law with no historical foundation under the Supreme Court's own Bruen standard. And yet, the Ninth Circuit's track record gives every reason for caution. Whatever happens, this case is not over. If the en banc panel rules against gun owners, the Supreme Court is the next stop, and Kim Rhode has already made clear she is not going anywhere. You have a right. The Constitution does not hand out illusions. The Ninth Circuit has never overturned a California gun law at the en banc stage. Do you think Bruen changes that? Or do you think the full panel finds a way to uphold this law regardless of the historical record? Give me your honest prediction in the comments right now. I read every single one. And if you are not subscribed yet, we are 500 subscribers away from 2,000. Hit subscribe, it is 2 seconds. Then type Firearms Law Advisor in the comments, and I will personally thank you by name. Not a bot, me, every single one. Stay informed, stay legal, know your rights.